Tiền năng ký kêu.
It's a newly committed case.
Who's appearing for this?
I'm appearing.
You want to argue before framing charge?
I have to check the copies first.
Copies been served to you by the committal court. So, what is the charge?
101, 302.
Okay, we'll give her a chance.
Because I also have the commission.
Accused Sen Lanki Daryam, alias Lanki, produced from jail through BC. Prosecutor also present. Legal aid counsel Srimati is also present. On the prayer of the defense counsel, the matter is fixed. The matter is fixed for hearing before consideration of charges. Accused remanded back to 14 days judicial custody. How long is in custody?
7 months. Can you pass?
Your Honor, there's no report on the summon issued to the IO. I communicate with the IO, he stated that it has not received a summon.
Is the IO?
Yes, he's the last witness.
Who is appearing for the accused? Karpan Bhashila. Who is appearing for the accused? Where is the accused? Additional prosecutor Srimati is also present. Accused absent without any steps. Defense counsel absent without any steps. Summon issued to the witness SI R.A. Sangma not returned. Prosecution shall take steps to summon the witnesses only after the presence of the accused and only after the accused appears along with the defense counsel. Thanks for the appearance of the accused and defense counsel. Yes. In the meantime, you just examine it.
Okay.
Where is this person posted?
Oh yeah, I got his new address today morning. So I'll give the new
You
address.
summon him only after this.
Yes.
Yes. Yes.
And this is there's no
Discrimination of witness, no witness.
What is this matter?
You are not the accused is in and I think for evidence.
How long he's in custody?
And earlier he was on bail and again he was arrested on the strength of NBWA. So I haven't calculated and checked it.
Prosecutors also present. Accused Marcus Pillay present. Produced from jail Azad through BC. From the record, it appears that prosecution has not taken any steps to summon the witnesses. Stop. The detention of the accused is for the purpose of trial. If the prosecution has not taken any steps to summon the witnesses, and no plausible reasons has been assigned for not taking any steps, the accused cannot be remanded casually. Defense counsel submits that the accused was enlarged on bail by the order dated so and so. He failed to appear. As such, non-bailable warrant was issued for securing the presence of the accused. Consequently, the accused was arrested on the strength of non-bailable warrant and he is languishing in custody. This court is not inclined to remand the accused persons to custody as the prosecution has failed to take steps to summon the witnesses without any plausible reasons. The accused Marcus Pillay is allowed to go on his previous bail granted by order dated so and so. Issue release notice. Prosecution shall take steps to summon witnesses.
Yes, President.
Yes.
For final agreement.
Yes. 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 Will hear it?
Yes.
Jiran will hear it. Suchian will hear it. Who is appearing for prosecution? Will hear it?
Yes, sir.
Yes. Yes, yes. Yes. Yes, what is this? What is this? This is yesterday's case?
Yes.
Yes, please show me an authority on that matter. See, please read first section 227. Read section 227 and 228. Will be governed by the BNSS or CRPC? CRPC. All right, please read section 227 and section 228.
To seven discharge if upon consideration of the record of the case and the documents submitted therein and after hearing the submission of the accused and the prosecution in his behalf
the judge considered that there is not sufficient ground for proceeding against the accused.
Okay,
He shall
okay,
discharge.
okay. Up to 228.
Framing of charge.
Hmm.
If after such consideration and hearing as aforesaid, the judge is of opinion that there is ground for presuming that the accused has committed an offence which is not exclusively triable by the court of session.
No, that's what. See, section 228, subsection 1. The grounds on which, what are the parameters for discharge? What are the parameters for refusing to discharge? For discharge from the material on record, if you can convince the court that there is no sufficient ground for proceeding against the accused. If there is no ground for proceeding against the accused, he is entitled to be discharged. But if there are grounds for presuming that the accused has committed the offence, then charge shall be laid. So you have to make out a case that there is no ground for proceeding with the case. From the material on record, we cannot draw any inference that ground is made out for proceeding against the accused. One. Second, the question with regard to power under section 227 can be exercised when a plea of self-defense is raised. You have any decision that the exception can also be argued at the stage of 227?
Your Honor, it's one of the rarest case. I cannot
Give
find
me the citation if you
I
rely on
cannot
you.
find the specific citation that speak about the plea of self-defense at the stage of framing of charge. However, there's one that related that speak about the 227. The SCI
You just give me the citation. 2010?
Yes, 2010.
And then we have that. Which paragraph you read? 2010. That's from South India, isn't it? The name, party's name?
P. Satha Visam and Major Datu.
Yes, the judgment says what? It relies on 1970. It relies on the decision of 1977 that Dinesh something, and it says that the for the purpose of framing charge, only suspicion should not be there, but it should be a grave suspicion. Court should not be like a post office.
This is 2020 case.
Then they relied on from there only they relied to 2020. That of course we understand the scope of 227. All right, we understand, but we are on some other question. That's why I brought to your notice section 105 of Evidence Act. Section 105 of the Evidence Act says that the exception, if you are taking a plea of the exception under section 97, or you are taking a plea of exception under section 84 of IPC, then it is the burden of proof is on you. Now, can we get into the question of burden of proof at the time of framing charge?
Your Honor, the burden of proof is beyond reasonable doubt as to
No. See, section 107, section 105 of the Evidence Act says that the court will presume. Please read the last part of section 105. 105 says that the court will presume that there is no exception. Evidence Act. When a person is accused of an offence, the burden of proving the existence of the circumstances bringing the case within any of the general exception in the Indian Penal Code or within any special exception or proviso contained in any part of the same code or in any law defining the offence is upon him, and the court shall presume the absence of such circumstances. We will presume that there was no self-defense. We will presume that the person was sane. Now it is for you to satisfy this court that your case falls under the exception. Now this you can do during the course of trial while appreciating the evidence. So we want to know, even at that stage of framing charge, you can advance an argument to satisfy this court that your case comes under the exception. Then we look into it whether you make out a case, for discharge, or the act is not an offence at the time of framing charge also. There is a latest decision from the Supreme Court is that a person should not be made to stand for trial if there is no case is made up. But at this stage, can you raise the plea of self-defense, or for that matter, exception, that the act otherwise is not an offence? Section 97, you see.
And 70, right of private defense of the body and of property. Every person has a right subject to the restriction contained in section 99 to defend the first part.
All right. See, you're not getting my point. Your act of causing death was in exercise of your right to private defense. This is your case, isn't it? So whether you can make an advance an argument at the stage of 227.
No, I couldn't find such a citation. That's
Let me
in
check.
40.
Pass me the decision 2010. The one you were relying.
Point number 10, Your Honor, page 86.
This is on the merit. See, you are not understanding my point. That's why I made you read section 227 and section 228. Section 227 provides that if there is no ground made out for proceeding against you, then you are entitled to discharge. From where, if no ground is made up? From the material available in the charge sheet. So that is on merit. We will not appreciate the evidence. We will not attach any. We will not start evaluating the evidence. But we will just look at the evidence the way it is. You say that for argument's sake, let us presume that the evidence which is there in the charge sheet is true. For an argument's sake, let's say that because during trial, the prosecution will establish the charge sheet. So without the charge sheet being established during trial, you say at this stage, I admit everything which is there in the charge sheet is true. And from there you start arguing, still no offense is made out. Then you are entitled to discharge. Why should you stand for a trial when the material in the charge sheet does not constitute an offense? It will be a sheer abuse of power. That is on merit. But you say, no, the material in charge sheet, let it be true. But with these materials, my argument is that this offense I have committed in exercise of my right to private defense. So it is no offense under section 97 onwards. So whether that argument can be, because the law provides that the burden of proof is on you to bring your case within exception. To what extent? How do you discharge this burden of proof? To convince this court that there is no ground to proceed against me with these materials. And while doing so, we will be appreciating the evidence. We will be appreciating the evidence, which is not permissible. Whether that was in exercise of your right to private defense or not. This is a subject matter of trial. But if you can convince me without appreciating the evidence means what? Looking at the authenticity of the evidence. But if you say that no need to appreciate the evidence, look at the evidence the way it is, still no offenses made. And I asked you deliberately to read section 105. If you read section 105, the court shall presume the absence of circumstances. Last part. The court shall presume that there is no exception. And when you read section 228, it says the judge is of the opinion that there is a ground for presuming that the accused committed the offense. The presumption is there. And the word used under section 105 is shall presume. What is the difference between may presume? This presumption is what? It's a legal friction. It's a legal friction. Something which does not exist, but it exists in the eye of law. If you have any decision, of course, we will examine it. First, you satisfy that in exercise of power under section 227, this presumption can be dislodged, or you can rebut this presumption. Rebutting the presumption will amount to appreciating the evidence. Can we appreciate the evidence? We can, but only for limited purpose. We examine if whether ground has been made out to proceed against you or not. Only for that purpose. Not for the purpose of saying that this what the witness has said is correct or is incorrect. No, that we can't do that. It amounts to trial. So what is the last order? Her learned prosecutor, see so and so. Her learned counsel, Srimati so and so. This matter has come up for hearing before consideration of charges. Before this court undertakes to consider the argument advanced by the rival counsel, it is apposite to bear in mind that at the stage of consideration of charges, the court would not appreciate the evidence and in event of the court decides that there is no sufficient ground to proceed against the accused, reasons has to be assigned. However, if the court is of the opinion that that ground exists for presuming that the accused has committed the offense, elaborate reasons need not to be assigned, as it would cause prejudice to the parties during trial. In the instant case, charge sheet has been filed against the accused under section 302 IPC. The prosecution is relying on how many witnesses? 7 witnesses to bring home the charges. There is an eyewitness in the instant case. The defense heavily relies on the statement of the eyewitness for discharge of the accused. Learned defense counsel has canvassed that the statement of the eyewitness reveals that the accused had exercised his right to private defense. As such, the act of an accused is no offense in the eye of law and prays for discharge of the accused. A learned prosecutor submits that there is a prima facie evidence manifesting that the accused was involved in causing death, whether the death was caused in exercise of private defense cannot be decided summarily. It is a subject matter of a trial. This court, after hearing the rival counsel and on examination of the material on record, more specifically the star witness of the prosecution, finds that the parameter for exercise of power for discharge under section 227 and for refusing the prayer of discharge under section 228 are different. In order to succeed for discharge, the defense has to convince the court that there is no sufficient ground to proceed against the accused for the offense charge. The prosecution, in order to dislodge the prayer of discharge, has to satisfy the court in forming an opinion that there is ground for presuming that the accused has committed an offense. Full stop. When a plea of exception is taken by the accused, the burden of proof, the burden of proving the exception is on the accused. Section 105 of the Evidence Act deals with the situation. For easy reference, it is reproduced. Section 105 envisages that the court shall presume the absence of any exception however this presumption is rebuttable. Reading section 105 with section reading section 105 conjointly with section 228 of CRPC, reading section 105 of the Evidence Act conjointly with section 228 of the Evidence Act of the CRPC, it emerges that section 105 creates a legal friction of non-existence of the exception and this legal friction forms the ground for presuming that the accused is involved in the commission of the offense. It can be rebutted during the course of trial. Full stop. Keeping in mind the above discussion, the statement of the eyewitness is examined only for the purpose of arriving at a conclusion if ground for presuming the accused is involved in the commission of the offense. Full stop. This court finds that there is a prima facie evidence to show that the accused was involved in causing death, whether it was in exercise of the private defense is a question of facts. And the same cannot be determined at this stage. Any attempt to determine the question of right to private defense would amount to appreciating the evidence at the stage of consideration of charge, which is not permissible. This court finds from the material in the charge sheet that there are sufficient ground to presume that the accused was involved in the commission of the offence, which is sufficient for framing charge. A prayer for discharge is rejected. Charge shall be framed against the accused under section 302 IPC. Any observation made by this court while passing this order? Shall not have any bearing on the merit of the case or cause prejudice to the accused in raising the plea of right to private defense during trial. Please for framing charge. Where is the accused? UTP. No, don't fix it. Charge frame against the accused. Charge frame against the accused under section 302 IPC. Accused pleaded not guilty. The accused shall stand for trial. Prosecution shall take steps to summon the witnesses. Bring the accused to frame the charge. Had you prepared your case, still had you put up your case properly, we would have discharged you. Only on the question of jurisdiction, only on 227. What is the scope of 227? You are not bringing any material which is not part of the charge sheet. You are arguing from the charge sheet. That's the plus point we have. But 227, 105 says that you presume, and 228 also talks about presume. And the word they use there is shall presume.
Presumed in absence of.
Means I don't have any discretion that I should not presume, but I am bound to presume. Look section 4 of the Evidence Act. What is the distinction between may be, shall? Right. That you on the night of 16/3/2023 at around 11 p.m. stabbed. Olino Rimbai on his chest using pickaxe at Mokondur village and caused his death. You have committed an offense of culpable homicide amounting to murder, which is punishable under section 302 IPC, cognizable by this court. Yes. Okay. Okay. Yes. Ask him. Yes, yes. Yes, yes. Make it fast, please.
Me hagani ke met ke khanru trip na beli aja akuli ai por khat bi ji met the to dung me yong niu ma olino rambai ha ha chas yang oma hani ha yang ki chas bai kata da pen kami do tu tiar man kam go wai ha mo kendur te the boy sedo yam te ne te the let me ni kam iwa boy sedo ke jing penyap mah tada penhap yang kita hapok ni ke section ke le not ar yang ke IPC you on me tam let mom em
Okay, yes, next. Next. Can he pass to me? That's all right. He please, he did it?
no no as fans and he said he did it
Repeat it again.
wa hagni ke met khanru trip na beli arja akule he por khat bi ji met the to dung yo niu ma olino rumbai ha rupa yang o pen em kami do niu tu kam goi ha mo kendur chnong te the boy sedo ji jing yap yang o te ne ti dau the let me ni kam wa penhap ini che nong penyap the penhap ro imi hakani ke kendon ko wa list pa ar yang ke IPC te let mom em mai tam
Why?
wai let me tam
Sẽ thổ hỏi từ phần mà
một nei dau sa wa let me tu besi pun poi mi hado to put
và với đau rồi cái bây giờ
you da mi ke bai me to protect his mother
So he killed that man. His stepfather.
penyap mi omo
hết nó mình đã được vào đặt để ý vật điều thế này
Can you be a bit loud?
kelam yang het mah yuk senyap so
chân nhịp cái lệ
One second. On 16/3/2023,
2023
he killed his stepfather by stabbing him on the chest.
no your honor after he struck him then they left the house
No, no. The charge against him is this. He killed his stepfather by stabbing him. Did he do that?
penyap mi opa mi they were dung mi dep let me ta
lệ
Hmm?
yes
It is an offense under section 302. And for that, there is a punishment. Either he may be sentenced to death or he may be sentenced to life imprisonment.
Ye ni jing le mi ye gi me pen ha pha do wo ye me chang chirta ha jil ne ye gi o mot phasi ye me ra.
Has he done it?
That let me can I have things can no.
Lệ.
Kan tani wa ông me. Kan tani wa ông me. Ni down le.
Lệ ô wa ni we dai beo. Wa một vào trận.
Judge may explain to the accused the language he understands. Accused pleaded guilty. Accused pleaded guilty to the charge. Stop. Next panel. If the accused pleads guilty, the court may, in its discretion, convict the accused thereof. Section 229 of the CRPC provides that the court may exercise its discretion to convict the accused on the plea of guilt. Stop. The defense has raised the plea of right to private defense. It is a settled law that the right to private defense, even if it's not pleaded by the accused, the court, while appreciating the evidence, can form an opinion, can arrive at a conclusion that the act of the accused was in exercise of right to private defense. What is age?
Kawan senang ta.
Yar puli.
23.
He studied to which class?
Dok kawan nice school me class.
The accused.
Class 1.
The accused is aged about 23 years and appears to be illiterate. Not very well conversant with the legal proceedings. not very well, not conversant with the intricacies of the legal proceedings. This court is not inclined to accept the plea of guilt. And convict the accused. Cases of this nature, where the offense is very serious, it will be appropriate to determine the charges based on the evidence rather than plea of guilt of the accused. The accused shall stand for trial. Prosecution shall take evidence, take steps to submit. Yes. Yes.
This matter is pending for cross-examination of some witnesses. But during the pendency of this case, we have filed an application. We have filed for quashing of this instant case. But the matter is still pending for the High Court, and the matter most probably will be taken up this 4th of November.
The accused Ken is still not present, along with defense counsel, so and so. Prosecutor C.S. Chansang present. Learned defense counsel submits that the proceedings of the instant case has been put under challenge before the Honorable High Court of Meghalaya. In CRP number give the number.
Yes,
Number so and so, and the matter is sub judice. Learned defense counsel apparently submits that there is no stay of the instant proceeding. However, the proceeding before the Honorable High Court would come up for final hearing on 4th.
most probably.
Probably on 4th.
Yes, for November.
November 2025.
Yes.
Fix this matter after 4/11/2025. The defense counsel shall apprise the court the outcome of the proceedings before the Honorable High Court. Yes. 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 Yes.
Your Honor, I have not received the copy of the petition, so it will be supplied to me. And at the same time, I have already prepared this one petition from my part, which I have stated that I do not have any objection provided the death and sureties of the deceased brother is used for the welfare of the children.
We will decide this matter. Let it go for trial.
I don't know.
We will decide this matter. Let it go for trial.
Yes, yes.
We will decide what is the right of the sister in the brother's property under the customary law. under the customary law, self-acquired property of the brother. In a self-acquired property of the brother, be it movable or immovable property, what is the right of the sister? What is the right of the sister on a property of the brother? See, once you don't have any right, you cannot impose any restriction with regard to the property. You cannot impose any conditions for how you're going to, how the person, if you are the owner, somebody does not have any right, how can you impose some restriction as to how you will use the property? You are all party to that settlement. You are also party to settlement. You are not aggrieved.
No, Your
Actually, at this stage, we don't have, he's not aggrieved, nobody is, but we don't also have any objection for this. So as leave to the discretion of the court.
It is filed by you.
Yes, sir.
In which paragraph you stated that you have got no objection?
Paragraph number 5.
Hmm.
Yes. The OP number 1 back to state that she has been informed that the petitioner has filed a succession certificate before this honorable court in respect of the debts and securities left behind by her deceased brother. The number 6, the OP number 1 and the petitioner have settled the matter amicably as the petitioner had undertaken to use the debt and securities left behind by her deceased brother for the welfare of the children, Your Honor.
Yes, what do you
as a wife of the late deceased, Your Honor, I'm not aggrieved with the as per the settlement agreement.
No. If you are part of the settlement, how can you be aggrieved? After you have settled the matter, how can you be aggrieved? Whether you are party to the settlement, then you are part of it. How can you say that I have arrived at a settlement at the same time you are aggrieved with the settlement?
Not,
Whether it is no settlement, you say that I have not settled the matter. If you have settled the matter, you have settled the matter. How can you be aggrieved and at the same time settle the matter? You are signatory to this
yes.
settlement? Where is the settlement? Who is Rikimen Power? The sister.
OP number 1.
But has she agreed to your condition that you'll use the money for the welfare of the children? No, she has agreed.
Yes, they have agreed.
Where? You ought to have filed a joint petition.
We'll file a joint petition.
No one decided. So what do you have to say on this? You have served the copy.
Yes, I have, sir.
What is your take on this petition filed by them?
For this. Since they have no objection, Your Honor, so we'll proceed for evidence of the petitioner.
What evidence?
They have no objection.
You have no objection, you pray for.
You have no objection. It is not that simply they don't have any objection. They have no objection with certain conditions. Have you read the petition?
Yes, sir.
It is not that they simply don't have no objection. They have no objection with some conditions. This no objection will come into operation if you fulfill those conditions. It is not an unconditional no objection. Tell us what is what you want to do in this case. You want to matter to linger around, we will keep it.
While we will file a joint petition, Your Honor.
Huh? What do you want? You are the petitioner.
Success certificate, no?
Yes, we want sufficient certificate, Your Honor.
On these conditions.
Yes,
You agree with these conditions?
with the families of the my husband. I agree to their conditions. Yeah.
Can you make such concession on behalf of your client?
I've been instructed by them only, Your Honor,
Huh?
by the petitioner only.
Well, these instructions has got some financial implications. Tomorrow you'll say that I've got instruction that give half the money to them. Then it has to be with a signature. So what do you want in this petition? If you want that this matter to be decided, then we'll decide whether they have got any right or not to impose conditions on you. Whether they have got any right on the debt and sureties left behind by the husband. Sisters have got any right. If they don't have any right, then all these applications should be dismissed. But if they have right, then forget about they asking 3 lakhs. You have to give all the sisters equally. You take only one portion. If all the sisters have got the right on the property of the brother, then they will get equal rights. Equally, you have to share. There's now no more conditions about this giving you, taking care of the children or anything. But if we decide that under your local custom and tradition, the sisters also have right on the property of the brother, then there is no question of giving 3 lakhs, 4 lakhs. The entire 15 lakhs will be equally divided among all. You'll get only your portion.
Then I need to speak with the petitioner, Your Honor, regarding this their rights.
We will decide, not the petitioner will decide. Tell us what you want. Now what do you want?
As instructed by the petitioner, Your Honor, I have no objection if they receive 3 lakhs. For this, before this court, then I pray for succession certificate, Your Honor.
I don't understand. You prayed for succession, but they have filed objection, no? You prayed for objection, we would have granted succession to you. But now they have filed an objection, we have to hear them. And they say that we have got objection to the extent that if the succession certificate is granted to you, how the money is to be utilized, they have kept a condition.
Then we hear their
What do you want now? Tell me, you're just wasting our time. What do you want in your succession applications? This is the application filed by them, they have filed objection. What do you want? The matter should proceed, we should frame issues and convert it into a suit. Or you want to amicably settle, or you want that no, I don't want to give anything. If I have to give, I'll give out of my own volition. They cannot dictate any terms because they don't have any right. No, what do you tell me? We have already wasted quite some time. Tell us what do you want now?
since we have already settled, Your Honor, let the succession certificate be granted.
To them.
No, in my favor.
But they are not agreeing to that now. They say that it be granted on the condition.
See, if that debts and securities left by the deceased, my brother, they use it for the welfare of the children, then we have no objection to grant, to issue that certificate in your favor. think, Your Honor, they need time with this to consult with their client.
Say so, then what for you're waiting?
Yes. Because last time it
How
was,
much time?
it was,
1 week here.
Like also for the petitioner.
but you know, by next week, no, I'm not be able to come from the 3rd until the, I'll join only on the, by Monday, on the 10th, 10, 11 onwards. 10, 11 onwards of November.
Very briefly tell what you want. You want to dispose of, we'll dispose of.
Give me 1 week time here. Up to 1 week, any date.
The petitioner. Sri Diva Dakar. Give me succession. The petitioner. Sri Diva Dakar. And file an application under section 372 of the Indian Succession Act. 1925. Inter alia. See, if you don't come to any kind of a resolution, in that case, I'll register the objection. And once the objection is registered, succession application, if any objection is raised, it turns into a suit. Now, if it turns into a suit, I don't have a jurisdiction to try.
Yes.
It has to be transferred to district council.
All right.
So what do you want?
From my part, I don't have any objection that succession certificate is to be issued in their favor.
Inter alia praying for grant of succession certificate with regard to the death and sureties left behind by her deceased husband. What's the name of husband? Barkat Pawar. On the first motion, this court was pleased to issue notice by the order dated 31/7/2025, calling upon the interested person to file objection, if any. The sister of the next one. What's the name? Your name?
Recommend power.
The sister of the deceased. No, Srimati recommend power, sister of the deceased. Entered appearance on 17/9/2025. And file an application praying for impleading her as a party in the instant proceeding. This court was pleased to array the sister as opposite party number 1 by the order dated 14/11/2025. Stop. Next one. OP number 1 has filed an application today stating that he has no objection to the grant of succession certificate to the applicant if the applicant undertakes to utilize the money left behind by her deceased brother for the welfare of the children of her deceased brother. The application filed by the OP number 1 today is supported by an affidavit duly verified. It appears that the objector has no objection to the grant of succession certificate to the applicant with regard to the debt and securities left behind by her deceased husband. This application can be disposed of after examining the material placed before this court. The applicant has approached this court by way of an application under section 372 of the succession certificate of the Indian Succession Act. The application is supported by an affidavit the applicant has stated the applicant has pleaded that she is a bona fide, that she is a permanent resident of Sabah Musiang village and has produced
Muswang.
and has produced EPIC card, which is exhibited as Exhibit 1. The applicant has also pleaded in para 2 of the application that the deceased was her husband and they were staying together since 2000, and out of the matrimonial relationship they have 4 issues. You did not give age also.
I have enclosed their birth certificate.
What is the age?
The eldest is 23 years, yeah. The second one is
Namely, give the name and give the age also. Copy of the birth certificate of the children is produced and marked as annexure. Marked as exhibit. What are the documents you have given?
death certificate.
Some other day will dictate it. Not like this, please don't do that. If you are claiming 15 lakhs, this is not the way you are filing an application.
Good day.
Yes, yes.
Yeah, no, this for people's of IO, with people. But is have some urgent work today, so I pray the court to allow to release it, this murder tomorrow.
This matter is proceed ex parte.
Yes, sir.
Counsel for the claimant, PD present. And please for time. On the ground then. CW4, who is a police officer,
Yes.
could not appear for his court. Pray along. He could not appear for his court today. Pray along. Refix for examination of CW4. Yes. 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 How much time will take?
It won't take much time.
We see.
After the incident, the accused person, they went to stay in a house for one night.
What case is this?
30.
302.
People go in Yama on smile kami ha.
Di Hoptani,
This case, two accused person after committing the offense were arrested from a place. They took shelter in the place.
Oh.
After the incident,
The pitch pang is tak kenal je ma. Tak.
Ratarik benanungkong arajar so for Preston the kersi yungi
Aja. Hewan sa ave.
alarm
Nak rembai biji sa ave.
samen
I know about this instant case. On the 8th January 2024, around 8:30 p.m.,
Tapi bukan itu.
van giwa usarsnya
Biji.
de bormida
Itu aku charge-nya.
upayar veya
my cousin brother, Sri Jarisnyao Dekhar, Deibor Miyongpur, and Sri Deibor Midhar came to my rented house at Larambai, where I was staying.
At what time?
She said 8:30.
That means they man the one come on.
van giwa Preston kersi yungi
She can be a bit loud.
Kelam rap yang hikmah.
Preston poigi kersi yungi mana kersi yungi tiyo ada bormi de bormi wa usarsnya ongi yang ase
Yang Jama. My cousin brother Sri Jarisnyao Dekhar and Sri Deibor Midhar came and knocked at the door of my house.
No, she said Kirsio.
Yeah, knock at the door of our house, Kursu.
Kirsio will be waking her up.
Kursu, if
No. Knocking the door and Kirsio is two different things.
she said knock at the door also.
She said Kirsio, not knock the door.
No, she said that come on,
Then let her say.
Yung pinga po yung sama de tia de kersi yungi teman de wai yung iki de yo wau
Kersi yung higaman.
di sok gise ongi adu wai
So ye.
adu war
Yes, they knock at the door. My cousin came to my house. No, came to my
cousin
house.
brother Shri so and
Came to
so knocked at the door of my house.
And asked her to open the door.
Yeah. Knocked at the door of the house. And asked me to open the door.
Demita,
teman de wai yung de yo ada jas nyor kar de bermidar tang de adu jas nyor ngasa bayar bayar ang sai tia im tu chim ini
yang my cousin brother told me,
No, name.
Jarisnya, my cousin brother Jarisnya, told me that he will stay in my house for one night. That they will stay in my house for one night. The man only pigam te kaman ong pi.
ông ấy cứ sao cắm nút thiệp vì niệm em than em nem để xử lý với em nữa sẽ
I told them I told them that how will they stay in my house as I don't have any cloth or blanket to give them. Only mat is available.
They will stay in my house for my cousin brothers told me that they would stay. No,
They will stay in my house for one night.
They will stay in my house for a night. I told them. I told them that I did not have
Cloth or blanket to give them.
I did not have any blanket, and
I didn't have any cloth or blanket to give them, whereas only mat is there.
I told them that I did not have any blanket to give them. I had only mat.
Mana dep ong pi ki kem te kaman.
sao ông cứ sao ông cứ cái gì nếp vì bam lại li him le ông cái kurim mà
You ong pi se te.
just now ông ta khar
Jarisnya ong yo lihim lewan.
cái ông cái kurim yang ông
Kurum yang jarisnya. Kan sa ga.
para jan yung
Kurum yang jarisnya.
kalau sa wai cái say thì porcelain.
Then my cousin brother Jarisnya told me that he will go and take the blanket and food from his wife's house, who is staying nearby her house, who is a neighbor.
That he would
Go and
get blanket from his
wife's house.
Blanket from the house of his wife, which is nearby. Yes.
Kita wan ra gi về bam với
Một đong gi piu lai thì một lai cái nem em nữa sẽ.
the live day for me that tàu just now the car sa và trong spa yung day for me lại đi về bam với cái gì nè.
Then they bore me the car, went to take the blanket and food from the house of the wife of Jarisnya. Went to take the blanket and food from the house.
Went to the house of his wife and brought a blanket. And where was this other fellow?
He's in our house only. Jarisnya is in our house while they bore me. He went to take the blanket.
All right. This Jarisnya went to take blanket. Went to the house of his wife and brought a blanket. They went to the house of his wife and brought a blanket. Stop. While Jaris while they bore me, went to bring the blanket. Jerry was in my house. Yes, then?
Ngân lâu anh u day for me that the bam cha langi peling udi. Mandi di bam cha the siang seliak i panas siang i gitu tiagi.
After they bore me came back, then they had a dinner, all three of them. Mana de piba.
Depi bam the siang seliak i panaki se the tiagi.
After they had a dinner, all three of them.
We had dinner together. Yes.
Then they went to sleep.
Where did they sleep?
Kihen thiagi.
Akan tahu.
Ai kamera.
Jitku dari yung chonga the ki tiagi trong
We had dinner together.
Kia
Thereafter,
trong palong kia akan tahu.
They slept on the floor of the house, both of them.
Thereafter, they bore me and slept on the floor of the house.
Naman tiai dap stage siang nuan em biang ba tịt dung
Kanu je roi te tipi.
por gam te insan khat ar chi te komi te thia te no te man da vai yunga te yo di pulin
Em te yung. Ta.
te man da vai yo te yo
While then they went to sleep. After that, at around 12 p.m. midnight, then she heard again somebody knocking at the door. And when she opened, it was the police. When she opened the door.
At around 12 o'clock, while I was fast asleep, I heard somebody knocking at the door again. Did you open the door?
Why do they?
te man da pa yo te yo di pulin
When I opened the door,
te vai sa
when I opened the door, I found uh, I found some police personnel. Yes.
Man the yo pi te man.
te man da vai dwaro te yo di pulin em ma prang yungar na di pungut asa te pulin la te nga te yo khngia dong na mai ye le apu pulin ha yungar na te man da sia gi po yung te pi yu gi nga di dur yong ki te tang gi na timit pi o ni de bor mi dar
When the police came to our house, outside our house, she was shocked at the first. She was very shocked, and then they
po yung
then some of the police entered inside our house, and then they showed her the picture of these two accused person. Man the deputy penyudur kaman.
yu sa yung te de bor mi tang ti ba u ne tang gi hinu dang tu tu thiao
So win.
te man de go pung khai te so chwa yang chwa te so chwa go de bor mi
Then some of the police entered
I
inside.
found some police personnel. I was shocked to see the police personnel. And then I was shocked to see the police. How many of them there were there?
Kanu di si expo yung di police.
ta ye bun bit ki te man sabr ga pi
Tipi ontan.
te wat si so san ngot em begin sa
Around 4 to
I
5.
found some police personnel. I was shocked to see. I was shocked to see the police. There were 4 to 5 numbers of police personnel. There were 4 to 5 police personnel. Some of the police entered my house and showed me the photograph of
They bore me. Asking.
How did they show?
Kaman penyo lipi tidur.
mobile
From the mobile.
Showed me the photograph of Devormi in the mobile phone
Asking.
and inquired about him.
And
I revealed to the police that Devormi was in the house sleeping.
yes.
Yes.
The man them.
te so gi o te pe yu biang gi sa yung jar snya de khar sa
Hewan penyo yo.
po mobile
Thereafter, then they showed another photo of Jarisnya.
They also showed me the picture of I told them he was present in the house. Then
Didn't them?
te kli gi sa gi won dang tu tu hi sa tia u ne te man da vai that gi o te pung khai biang gi o te so biang gi
I told the police that give the name Jarisnya was present in the house sleeping. Yes. Yes.
The man that on beyond that.
te vai that gi o te kersi gi o man kersi gi o te so biang gi ki penar ngudi man de te ayu ngam em du klam gi ya la de ya ki tip sin sthanat ma sa ye ma ya ki
Thereafter, the police took both of them, but she doesn't know whether they took them, whether to the police
They woke
station.
them up.
Yes.
Police woke them up. Or she
Yes.
woke them up.
Pi penari ki police kursugi. Ne both by the police woke them up, both of them.
The police woke both so and so and took them along with them. Why did they take them?
Le ya ki tipe.
Tiba temnete ya giki de ngamem do ti asim simit lang asa ba yo tenya untuk man te no den si lesni susni gam tu perdisni po biang kulit la berato
On that day, she said she doesn't know why they were taken by the
I did not
police.
know why the
But
police had.
after 3 days, the police
I
came
did
back
not know why
again
the police had
to her
taken
house.
so and so. Taken this one. It was after
3 days. 3 days.
it was after 3 to 4 days. The police from Barato came to my house.
The man one gi tigi pulit UP denite.
mandawan gi dete ongi nga te ikot gi nga sa egi baya kete ga dilis ga krumutar nyau baya nga ta phalang gi penarun si sabrato sa police station te mana po ite ta pili ta kit gi kam kili gi nga ini kam te kana thale
After this 3 to 4 days, she along with the wife ki pratika
dilis
kurumyang deba.
yung tar nyau
She along with the wife of Jarisnya were summoned by the police and they went to the police station. And
The
then
police did not came to the house.
the police came on after 3 or 4 days. The police again came to her house and they gave them, she said, a paper and asking her along with the wife of Jarisnya to go to the police station.
It was 3 or 4 days. It was after 3 to 4 days. The police from Barato came to my house and informed me that I, along
With the wife
with the wife
of Jarisnya.
Srimati,
Delis syndrome is in them. The kurga. Delis.
it's no gatti ba te ikurgam mun sab ga pili
Kuno bi kurga.
was were required.
Delis, but she couldn't recollect her surname.
I, along with the wife of Jerisgao, Srimati so and so,
Srimati Delis.
was required to appear at Barato police station
Both of them they went.
on same day.
On the Hakataka Singi got ipi, live.
yo he
Mod Hakataka Singi one you put it young P. Got Kimod Hakataka joke was Singi live beside her. I didn't
te kon wan gi kamne te phagi nga kam mungubi
ask me.
adina asni
Mangowi, it's after 2 days they went.
2 days after
Receiving the
2
notice.
days after receiving the summons, I along with Srimati Dallas, we went to Barato police station. Yes.
And then on reaching the police station, they were inquired by the police regarding this matter. The P. Pohitan the TPP need down.
na poi tai ta kili gi nga de batai gi kama batai ini gam te batai ya te mandongi TVP ya lagi ti bon dongi wa ti abru gi te
When the police went to police station, the police made an inquiry from us and also revealed that both were involved in causing death. Whose death?
The P. to Panyaki.
Causing death of a person. Then
te ongi nga te wa kam te ti abru gi ne mem de uklam gi ya la ongi to de biang na tu te mem de pha gi nga sinu le te dang ni de poi kot biang te
That's also. Let it be her statement was also recorded by.
Yes, terus.
Now ko di jingli nu mama, hidden tu kena ni mah.
Be brief.
Copy the agreement.
Mình xóa mi tem em đi chung sa.
For one copy agreement. At the time when accused person came to my residence, I was not married. Did you open your side Jung? I stayed in my residence. I stayed alone in my residence. Ini jaris nhau, chua tu gumit, jowan bong nong sampai tu sam.
Em ngetet kisngi, boy ki ngetet kisngi rak polis le.
Chua tu chua tu gumit wan pulit se, chua tu jo emi por dong wan chong pi tu sam.
Aga bi kisngi ang bayi por mem cia kam tu de. Kamong de spayu ga de jo ya ba me di sa lang be se.
It is a fact that before 8/1/2024, the accused person jaris nhau used to
Was a regular visitor to my house.
yes, and he stayed overnight.
Was a regular visitor. Was a regular visitor to my house, and he would stay overnight in my house.
Ông Pi cầm qua khát aro chế quá tịt em một tịt waar đấy hiu lai waar từ waar hiu lai waar hi por wo waar pi tegi ông Pi pulit nam to dei sulai yung sap sula pulit when I opened the door I saw that the police personnel were in their uniform.
When the police appeared at my house in the night, they were in uniform.
Em pentimit kinam hithi một khana bertu ji pulit di pulit saya mong khana ji pino ngau te bertu jo ngau te ga rang so naga te thanak war mong khana ini the police
Did not introduce themselves.
their name, rank, and from which station they were.
Did not introduce. Did not introduce their name, comma rank, and police station when they came to my house.
They por wara ji jaris nhau tu they bor mi mem khana i bhai dau la rai kina
I was not informed by the police. Why? They had apprehended both the names.
They por wala ki support bar tu khana gi ong gi em kiti gi tu yap brung tu bru yap mong khana kulit dong tu
Karena bagi dem timi yo.
khana gi nam timit. Can I ask a question that whether the police informed her the name of the person who was murdered? She said that the police did mention the name, but he do not know the.
When I went to the police station, the police had disclosed to me the name of the person who was murdered, the name of the person who was killed. However, I cannot recollect the name.
Hal tu kami dong pi hadin merai kulit ki pi mem lai pi sebagai kurim yang jarisnya wa kena pi ta.
Nga dem ki ya ni te ta nga de chong yo.
So ye yung. After the police had taken away the accused person, after the accused person were taken away, I did not go to inform the wife of the accused person that is now the car. Tay porowan gipulit untuk dang ibam jadi. Tay porowan gipulit.
Mem di sa ambai wada juras ntia te mem di bam jai de sai pleng jak su ja nang samadan.
Membam jadi itu.
Bami I de mena de bami se tia tam ba rei ne ram
Apa jinggili yang ngamut tay por wadang bam jadi, tay porowan ini, ang itu pulit.
sai su ja nang samadan.
Ap jinggili yang ada miat, tay por wadang bam kita, tay por wa, em kursi dua, mana wa itu yuk itu pulit. Itu anda.
It's not a fact that the police came to my house while I was having food along with both with me.
Apa ang pi kita kiwa ang pi pulit na, memang kena lagi pi pertuji neganu ketanak wandi. Tengah ang ini wa pi menurut pi wang betok, tok sikit pulit nam tok kita gawan tu kembali. Tak baik. I'll just take back my question. That's all.
For further evidence, this one accused is on bail, isn't it?
They brought me the hand.
He's on bail, and the other accused persons are produced from jail through BC. They remanded back to 14 days judicial custody. Yes. Next.
Accused me sit down.
Yes. Yes.
This one for this accused Gerald Suchiang.
Yes.
You know, if I miss that, you know, how
Yes.
this go directly to the FIR, you know. If I may read, you know, the FIR.
Yes, yes.
The FIR, you know, was lodged here by the PW1, you know, Shri Champang Latong, you know. And the FIR states subject, you know, FIR Persha Yau Gerald Suchiang. Katkum kate kapang balak deu Haning ni kibahayeng hasem ni kwa banbu kajing ujor persha ya ujera suciang ukon jongka delina suciang basyong basa hamukhat namar ba menta kasni ka penduduk bana bispo arja katra hak por kumbas posting menstem ulapan mensal ya kabar bira suciang da kabaot na rendang da katari haying jongkahi hamukhat. But la punkit mar sha CHC leskeng namar bakal shitomjur ki doktor ki refer ye sha civil hospital yalong banyo ya keting sumat kapapaka tengi kum kiba haying hasam ngi karpat ye phi bapin shimkhia ye kane ka jingjia. You know, this is FIR, you know. And you know, now I would like to come to the statement of the victim, evidence, you know, evidence of the victim, you know. If I shall read another relevant part, the evidence of the victim who is PW2, you know, if I may read the relevant part, you know, he said that I was at home with my youngest daughter, Srimati Marbutki Suchiang, and the accused Gerald Suchiang. At that time, I thought of going to my paddy field at Mokaya village. During that time, I have asked the accused Gerald Suchiang by tapping him to also go to the paddy field of my sister, which is also at Mokaya village. As such, the accused got agitated, and thereafter he pushed me to the ground inside my house, and I felt unconscious. At that time, he also stated, Your Honor, thereafter I could not remember what happened, and when I regained conscious, I saw a cut injury on my chin. Your Honor. And you know, now I would like to lead some report to the daughter, you know, who is PW3, this Marbut Kisuchian, the daughter of the victim, you know, who was also present when the accused and the victim was at the house of the victim, Your Honor. She said that, I'll read only the relevant part, Your Honor. She said, on the day of the incident, when my mother was drying paddy outside her compound, and also the accused Gerald Suchiang was present in the house of my mother. As it was a reaping season of paddy, my mother instructed Gerald Suchiang to go to the paddy field for cutting paddy. Then accused Gerald Suchiang refused to do so, and as such, it has led to a verbal spat. After that, I took some clothes and went to a place called Umso for washing clothes. When I returned back home, I saw my mother injured below her chin and was lying on the ground unconscious. And now, Your Honor, I'll lead the dishonorable court to PW6, Your Honor, who is the doctor, Your Honor, of examined the victim, Your Honor, at Laskin CSC, Your Honor. I'll only go to the finding of the doctor, Your Honor. The finding of the doctor in the examination part, which is point number 4, external injury, Your Honor. There, in the external injury, it was mentioned there was a large 10 centimeter by 5 centimeter in size cut throat injury involving anterior aspect of neck just below the chin and on the left side of the neck. Your Honor, why I need some code from the FIR to the evidence of the victim, evidence of the daughter of the victim who is PW3, and okay.
Give me the scale. Ruler. Can you explain me this 10 centimeter and 5 centimeter?
10 centimeter in length, Your Honor, and 5 centimeter in depth, Your Honor.
Depth?
I don't know, Your Honor, but it's just.
That's what I want the explanation of.
Okay, Your Honor, but going through the exhibit, Your Honor, which is exhibit 6, the medical report, Your Honor.
Paper mark, not exhibit.
It was exhibited later, Your Honor, as exhibit 6, when the doctor was recalled again.
So let me see. Just explain.
Your Honor, a large 10 centimeter and into 5 centimeter. As to this also, Your Honor, I cannot say, Your Honor, as to what 10 centimeter, what this 10 centimeter indicated and what is this 5 centimeter indicated. As a doctor here just plainly mentioned 10 centimeter into 5 centimeter, you know, without explaining what are this 10 centimeter and 5 centimeter.
Is the depth or the breadth?
That's what, Your Honor, I have no idea what this
5 centimeter cut on the neck.
10 centimeter by into 5 centimeter. That's what the medical report
what
reveals.
It is 10 into 5.
10 into 5.
Length into breadth. That's what we understand.
Length into
10
breadth.
centimeter into 5 centimeter. 5 centimeter is a big enough cut on the neck.
Big enough cut on, yes, sir.
10 centimeter, 5 centimeter deep means it's gone very deep. 10 centimeter on the neck.
On the neck.
Huge. And that too, incise wound.
Incise wound, yes, sir. Cut.
Throat injury, incise cut throat.
Incise cut throat
Involving
injury.
interior aspect of the neck.
Anterior aspect of the neck.
Just below the chin.
Just below the chin, yes, sir. Below the chin.
10 centimeter below the chin, it covers the neck.
Covers the neck.
And 5 centimeter. What is this 5 centimeter? 5 centimeter deep or breadth?
That's what, Your Honor, I'm not so sure with this, Your Honor. I cannot comment on this, Your Honor, since I left with no option, Your Honor, since it doesn't mention whether it's a length or breadth or depth of the injury, Your Honor.
No, look at the evidence of this person.
PW 6.
This lady, this victim was examined on 26/11.
26/11, yes, sir. 26/10, Your Honor.
10.
Yes, sir.
What time we don't know.
Time. No, Your Honor. No, man. No.
How far is the hospital from the place of occurrence?
It's just 5 minutes, Your Honor. Mukhab escape.
Okay. Yes, then.
While I read out the FIR fast, Your Honor, to this honorable court, Your Honor, I would like to bring the attention of this honorable court that the accused person is known. He's mentioned in the FIR that he is the one who had committed the crime, Your Honor, who has inflicted the injury wound on the victim, Your Honor. That's why I read out the FIR. And why I.
Who is the informant?
The informant is PW1, Your Honor.
How is related to the victim?
He said that he's getting married at the house of the victim, Your Honor, to the sister of the victim, Your Honor. He's related, very much related to the victim, Your Honor. So, Your Honor, and now why I let this honorable go to the evidence of the victim, Your Honor. So, here, Your Honor, to show that the accused is very much present along with the victim inside her house, at her residence at Mukha village, when the incident happened. This in itself show, Your Honor, that apart from the accused, there is also her daughter, Your Honor. There's also a daughter who is PW3. I'll come to the point why, Your Honor, I mentioned that. Apart from the victim, the accused, and the daughter who is PW3, Your Honor, there wouldn't be any question as to who had committed the crime, apart from this person present inside the residence of the victim. So, Your Honor, drawing the attention of this court that why the evidence draw towards the accused person is that the evidence of the victim stated that at that time she was about to leave, Your Honor, she also asked the accused person by tapping him to go to the paddy field of her sister, which is situated at Moria village, Your Honor. She said that as such, the accused got agitated. There in itself, Your Honor, the accused got agitated and therefore he pushed me to the ground inside my house and I fell unconscious. He pushed me to the ground because like he got agitated. Then he pushed her and then she fell unconscious. You know, here it's clearly that who had caused the injury, who had caused the harm against victim. It indicates that it was the accused person. And then she said that she felt unconscious. And then there's a part she said that when I regained conscious, I saw a cut injury on my chin. Here, Your Honor, the circumstance which has led, Your Honor, might be, not just might be, Your Honor, the circumstance which has led that the accused would have cut the neck of the victim when she was on the ground, when she felt unconscious. That's the part. And why I draw the attention that there are 3%, but it was reluctant to the prosecution, Your Honor, when the incident happened. This PW3, who is the sister or who is the daughter of the victim, she said that when her mother asked the accused person to go to battlefield, then the accused Gerald refused to do so, and as such, it has led to verbal spat. She mentioned that there's a verbal spat, there's a quarrel between the victim and the accused person. And she said that after that, maybe after she saw that there's a quarrel, she took some clothes and went to the place called by the name Umso, for washing the clothes. Reluctantly, she didn't witness, but there's clear indication there's a verbal spat between the victim and the accused. And why I'm saying that, although the prosecution short of eyewitnesses, but there is circumstance evidence linked the accused to the crime, Your Honor. Other than the 3%, the 3% were present at that point of the incident at the house of the victim. The only answer which led is that who had caused the injury to the victim is the accused, Gerald Sucheng. The circumstance will only point to one person, that is Gerald Sucheng, because it indicated after the
Yes,
come to
we got your point.
yes, sir. And then you know why I say that I draw the attention of this court to the medical report, Then medical report is clearly mentioned that is a cut injury, Your Honor.
Read the entire medical report.
Okay, now just
Second part.
yes, second part of the.
She was under the influence of alcohol.
Okay, Your Honor, I'll just cut.
Read the second part. Exhibit 6, second part.
Exhibit 6, yes, sir.
She was drunk.
The above noted person has consumed alcohol and she is under self-control. Self-control.
That goes against you.
Although it goes against me, yes or no, I am very much understanding it. It goes against the prosecution, but there is a word used by the doctor under self-control. Under self-control, that means she is very much in her sense, she can control.
How do you reconcile with this that she was unconscious and she was under self-control?
I will not reconcile to this, but I'll just go to the medical report on you. I'll just limit my argument only with regard to what the finding of the doctor.
Yes. Now, how do you reconcile? How do you reconcile with the medical report and the evidence of the victim? Let us not go to PW3.
Okay.
How do you reconcile to the evidence of the victim? We will not, we just on the that aspect of the matter. The victim says that when she was pushed, she fell down, she became unconscious. Right? But the doctor says that she was conscious. When she was brought, she was found to be under the influence of alcohol, exhibit 6. And she had cut injury below her chin. All right. She may have cut injury, but we are on a question as that who had inflicted the injury. According to your argument, the prosecution has brought an evidence that the accused, PW2, victim, and PW3 were present in the house. All right. Now PW3, you say is an eyewitness.
Not eyewitness to the crime.
PW3 was present there in the house. He saw there was a kind of a
verbal spat.
All right. There was, but she did not see any. She saw something verbal, nothing physical. And thereafter, since it was nothing very serious, she left the house for washing her clothes. Thereafter, what happened inside the house, she does not know.
She does not know. Yes.
Right. The person who was inflicted, who suffered injury, she says before the court that the accused pushed her. All right. And she became unconscious.
She became unconscious.
Right. Medical report says that there was an injury below the chin, 10 centimeter into 5. Let us say 10 into 5. It has to be length into breadth or length into depth, whatever may be the case. 10 centimeter is this much.
Yes, sir.
This is 10 centimeter and this is 5 centimeter. If it is deep, it has gone so deep. All right. And if she was unconscious, how did she become conscious and who took her to the hospital?
Here you are.
No, I'm coming to that.
Okay.
What the explanation required. The informant was not present there.
Yes, the informant was not present.
The fact stated in the FIR is that the accused had caused injury by slitting her throat or by cutting her throat, whatever you want to say. Now, this information, the informant got from whom?
The informant,
Who told him that the accused did that? Because he was not present there.
yes, sir, that's
Somebody might have told him, isn't it? Who? How did the informant came to know that the accused had slit the throat of the PW2? Who told him?
Your Honor, as for this, Your Honor,
Because the person who was present there, PW3, she's silent.
She's silent, yes, sir.
She has given evidence only to the point that the accused and the victim was present there. They had verbal spat. The verbal spat was not so serious that she would stay back. If somebody is being slit or somebody is threatening somebody with a knife, certainly the daughter will not leave the mother and go and see that the accused harms her. That itself shows that things were not so serious. She took her clothes and went for washing her clothes. The victim herself does not make any whisper about the accused using knife and slitting her throat. Person who was not present there, he files an FIR and says that the accused had slit the throat. How did he come to know that the accused did it? When the person was present there, he does not indicate even mildly that the accused carried the knife or he was threatening with a knife. Nothing of that sort. She says only verbal. So please explain me. How do you connect the dots?
Your Honor,
And you are saying that this is a case of a circumstantial evidence. Now, how do you connect the dots of the chain of evidence?
yes, Your Honor, where circumstantial evidence, Your Honor, here, Your Honor, when it comes like that the injury cause was a cut injury, Your Honor, pertinent to seizure, no seizure list, Your Honor, to the seizure of this material, Your Honor. Seizure list which will be exhibit 2, Your Honor.
When would the seizure was made?
The seizure was made, I'll come to.
Date and time.
What, Your Honor?
Date and time of the seizure.
Yes, Your Honor, I'll come.
And the object seized. Seizure list is exhibit?
Seizure list will be exhibit 2, Your Honor.
Yes.
Your Honor, the seize was made on the 27th, which is the very next day after the incident. 27, 10, 2000. It will be on 26 on the Honor, dated 26, on the very same date, Your Honor.
What time?
The time at around 3:30 p.m. Your Honor.
All right. When the incident took place, as per the prosecution case?
As per the prosecution case, 10:30 a.m. Your Honor, in the morning. Daytime, morning time, 10 a.m., 10:30 a.m. So, Your Honor, the seizure was made, Your Honor. I will read to the seizure list, Your Honor. Do hereby today, the 26th, 18 at around 3:30 p.m. seized the below noted property on being produced and identified by the accused, Your Honor. On being produced and identified by the accused, Your Honor. And here, Your Honor, what is seized is one local made down, in which one local made down. And that down in itself, Your Honor, is a weapon which can cause that injury which is found on the body of the victim, Your Honor.
He produced, isn't it?
Yes, he's the one who produced the
See. Incident at 3 o'clock.
3. Incident.
Any blood found in the knife?
What? No blood stain.
How do you connect the knife with the crime?
Just that, Your Honor, it was produced by the accuser.
All right, maybe. But how do you connect this weapon was used for slitting the throat?
Your Honor, that's what I say, Your Honor, because it was produced by the accused himself.
Maybe. You may produce, but then how do you connect this weapon with the crime?
How do I connect the weapon with the crime? That, you know, the local made now, which is a sharp weapon, Your Honor.
Right.
A sharp weapon which.
Where does it talks about the sharpness?
Nothing.
Total length is 1 point.
Total length is
1 feet 5 inches.
5
Bring the thing. Bring this way.
Yes, and you know why I connected? Because there is injury found on the body of the victim, Your Honor. The The injury found in the body of victim is a cut injury.
Yes.
You know, a cut injury which can be caused by this dagger, a weapon which is usually used for cutting.
See the length.
The length is 1 feet 5 inch, the length of the dagger, and the length of the blade is 8.5 inch, and the handle it will be 8.8 inches. With the handle.
Who saw the dao being used?
No one for that.
So in absence of any eyewitness, or in absence of any evidence to show that the dao was used, or this weapon was used for causing the injury, then you have to connect it through this forensic evidence that the blood was found. Look at the injury, 10 centimeter. Any blood was found, and that was the blood of the victim?
No blood.
Yeah.
Yeah. That's what but the prosecution is only left with that, that the accused was last seen with the victim inside the house, and that it is proved by PW3, who is the daughter of the.
Daughter does not say anything.
Yes, maybe she doesn't say anything, but
She only says that they had a verbal spat.
Verbal spat, yes, I agree to that.
Converting a verbal spat into attempt to murder, there has to be some evidence.
That's true.
So
That's
what is the
I
evidence?
just-
What is the evidence that this man had cut the injury, caused the injury?
Apart from I've gone through the evidence, okay,
Suppose they had a verbal
spat.
or they just had a heated argument. He pushed. The lady fell down and hurt herself. There will be attempt to murder.
Your Honor,
Let's say that he pushed. The evidence of he pushing is there.
yes, evidence of he pushed her.
Pushing and slitting throat is
It's totally different.
two different things.
Understand.
Pushing somebody is a very trivial matter. Now I understand is that you push somebody and he slips and rolls down and he dies. But your intention was not to kill him. You just pushed him.
Yes.
But accidentally he died.
Accidentally.
Suppose if a person is suffering from sickness, you slap him and he dies. You may be charged not for murder. But yes, you have accelerated the death. You may not have caused the death, but you accelerated the death. But what is the evidence that he hit him? He was the one who caused this injury.
That's what Your Honor.
For a moment, just forget the injury. Without that injury, what is the offense?
Without the injury, Your Honor, the offense would be, let's say, outraging the modesty of women, pushing her down, and then maybe she's.
No. If that is how we understand outraging the modesty of a woman, that means no man can touch a woman. Where does he says?
No way.
Where does the victim says that he wanted to outrage his modesty?
No way. No.
He had that intention. He had that intention to abuse her physically.
No way. That's what Your Honor.
So if that is how we understand outraging the modesty of a woman, suppose if it is a case of 323, then he said slapping a woman is also outraging her modesty. But the woman has to say that but the victim never said of that thing, and they are related.
And that's what I would like to make a final submission. In this case, unrelatedly, the prosecution is short of evidence, and to link there, connecting the dot against the accused person, and to the wisdom of the court, pass necessary other judgment.
Well, I want to understand this 10 centimeter and 5 centimeter.
That's what I fail to understand myself. I've gone through the record again and again.
You are prosecuting.
Yes,
Because,
sir.
you see, we have to be very realistic. We are not writing some art or some literature. Even if we are trying to accept, we are trying to appreciate the evidence and to arrive at a conclusion whether these evidence, those facts have been proven or not. But a lady with a cut on her throat, which is 10 centimeter and 5 centimeter, the bleeding will be
immense.
Literally half the throat is cut.
10 centimeters, I guess. What understand with the leg?
Let's see, where is the weapon? Yes, that's all?
That's all from my side.
Yes.
May I
Read
please?
it, 1984, volume 4, page 116. SCC 1984, volume 4, page 116. Sarat Birdichan was the state of Maharashtra. Yes.
May I please, Your Honor?
Yes.
Your Honor, in this case, the accused person is charged under section 326 of the, if I may be allowed to read my said section, Your Honor. Your Honor, here it has been said that voluntary causing grievous hurt by dangerous weapon, by dangerous weapons or means.
116. Volume 4.
So, Your Honor, the FIR which was exhibited before this court, the complainant, though he is not an eyewitness, it has been mentioned there that the accused has used a knife. Whereas at the time when seizure was made, the police has seized a dao. In Exhibit 6, Your Honor.
What is the difference between dao and knife?
A dao is a
Because
knife is a small one, a dao is a big one.
Since you are saying that the allegation made in the FIR is
Yes,
of a knife,
Yes, Your Honor.
Caesar was made of a dao.
Yes, Your
You want to impress upon the court that
Yes, Your
these are two different things. So
Yes,
what is
sir.
the difference between dao
Your
and
Honor,
knife?
usually a knife, it is used commonly here.
Ah.
It's used in domestic purposes.
Ah.
A
No,
dao
we are
is
not
used in
asking
the
about.
field.
We are not asking about what is the how do we use? What is the distinction between two?
The distinctions is just that knife is a small and dao is big. You know? That is the distinction.
Okay, we just open. Let's see. This is gone as material exhibit.
Yes, Your Honor.
Sure. So this is not a knife.
Yes, Your Honor. It is a dao. Yes.
What is that? Small knife.
No.
Small knife.
We can say that, but by the look of it, Your Honor,
What do you call this? What bell? This hook, na? They have got a hook in front.
here,
See the front.
Kumut,
Mood. The nose.
nose of the dao.
Try the sharpness. See the sharpness. Sharp.
Not sharp, Your Honor.
Is it sharp?
No, Your
Now it's blunt, you know. It's rusty. It's covered in rust, you know. It's been since 2018 and 19, 6 year lapse. Yeah.
No, I'm not convinced the distinction between knife and we cannot words. Yes. We can call it knife down, anything we can call it. But it is a weapon. It is a weapon. And through this weapon, the injury found in the medical report exhibit 6 can be caused.
It can.
If it was a dao maybe what we understand, a dao means a big one, a big heavy one. So it's not possible that with such a big dao you can cause.
Due to the fact that it has been used for quite so long, maybe that most of the material is
Become
not
rough.
sharp. Yes, Your Honor.
Okay. Okay. Yes. Yes.
And
Leave it there. Yes.
Your Honor, if Your Honor looks at the medical report of the victim, as Your Honor is well aware, Your Honor, here the doctor has not mentioned, even though he has mentioned 10 centimeter into 5 centimeter in size cut wound.
But the weapon used here has not been mentioned by the doctor.
Weapon used?
Weapon used for this assault, Your Honor, upon the victim. It
Why
has
will the
not been
doctor
mentioned. Yes, Your Honor.
Why will the doctor mention that?
Your Honor,
Is it
in
not
order
enough?
to prove grievous hurt, Your Honor, as
What is previous?
Your Honor,
Section 320 defines
yes, Your
grievous.
Honor, grievous hurt, yes.
Where are we? There are 7, 8 definitions.
Yes, yes, Your Honor.
We have to be in hospital for 15
Yes,
years,
yes.
16 years.
Yes, sir.
Do you think I'm going to stick to that?
My arguments.
When was this IPC 320 brought introduced there? And when 320 came incorporated under IPC, they use a person should be in hospital for 15 days. But now we have made a great advance in this field of medicine. A person can be treated within a day.
Yes, sir.
The length of time a person spends in hospital will determine the gravity of the offense or the efficiency of the hospital. Very efficient doctor can treat you. A person who has not been treated well and the sickness gets more or the injury gets aggravated by wrong treatment, he may be in hospital for months altogether. So the length of time spent by the accused person or the victim in the hospital, I don't think so. In this today's age, will be a determining factor. Because science has advanced in the field of medicine, we have made great advance. Lot of medicines have been developed. We can't take that length of time spent by a person in the hospital will determine the gravity of the offense. At least not now. Previous heard these definitions are there. Anyway, we have seen. Yes.
So, Your Honor, looking at perusing the Exhibit 6, the medical report, further, Your Honor, will notice that the doctor who have treated this patient, she has he has not given any stitches to the victim. Be the stitches.
We are not in a case of medical negligence.
Yes,
the
I
fact
understand.
that when the person was brought to the doctor, the kind of injury the person has
was only-
suffered,
she
that's
was
very
only-
important.
She was
How
only
he was
given-
treated, that's different issue.
She was only given first aid, Your Honor.
But look at the injury.
Yes.
Incise wound 10 centimeter.
As Your Honor has measured that incise wound.
We have measured it, but that is there on record. In your
Yes,
cross-examination, what have you said then?
Your Honor, in cross
How you have cross-examined the doctor?
And
Then a person survived with a 10 centimeter and 5 centimeter, 10 into 5 centimeter cut on the throat, and that too incise. So, but then that is the evidence which is there.
But Your Honor, this doctor has came before this court and he was examined as P. 6.
Yeah.
He has stated all these facts and exhibited the medical report. So, Your Honor, we have raised a question to him because even it's very clear here in this medical report that this person has consumed alcohol. So, we put a suggestion to the doctor. We put a suggestion, Your Honor, and in which the doctor agreed. I'll just read it out, Your Honor. It is a fact that since the patient is under the influence of alcohol, there is a possibility that the injury might have caused by falling down. The doctor did not say it is, but might.
The person who suffered the injury also came to the court, isn't it?
Yes, Your Honor.
So he is the best person to tell how did he receive the injury. Why will go to the doctor was present there?
No, Your Honor. But he was the one.
The person who received the injury had appeared in a witness box. So he or she was the best person to tell how he or she had received the injury.
Yes, sir.
So did you ask that question to him?
Your Honor, we did ask, but not that specifically that question.
What is that?
Okay, I'll just read out the cross, Your Honor.
Go only to the point of how did she receive the injury?
After that part, when the victim regained her conscious, Your Honor, she stated that the accused may have gone to call out somebody for helping her. And I agree that the accused did not have any intention to hurt me at that point of time. When the incident took place, both I and the accused were under the influence of alcohol. Further, Your Honor, it is a fact that the incident took place accidentally. In her in chief and also in her cross examination, the victim never stated that the accused person has got her.
Where she said, you admit that the incident took place.
As per the cross, Your Honor, going by the cross.
That means you admit, in the cross you have confirmed that the incident took place. We will see whether it was accidental or not. PW?
It will be true, Your Honor.
True. You admit. Nowhere she says in the chief that the incident took place. But in cross, you confirm.
But she never stated, Your Honor, that the accused person, he was the one who got it.
What does it mean? When the incident took place,
Your Honor, in her in chief, she stated that during that time, I have asked the accused Gerald Secham by tapping him to also go to the paddy field of my sister, which is also at Mukayao. As such, the accused...
she's dead or alive?
She's still alive.
Alive?
Yes, Your Honor. Just ask the accused to confirm.
No, what? Okay, what is the...
Ini ke kom Barbara ini kan? Barbara Susan. Your Honor, this incident which I'm referring in my cross is the part by tapping him to go to the paddy field of my sister, which is also at Mokayao. As such, the accused...
okay. You were there present in the house that day?
Yes, Your Honor.
What is the explanation? What happened in the house? In under 313, what did you explain?
Your Honor,
how did you explain the incident under 313? What is the explanation? Syarat berbicara. Yes.
Your Honor, he did not deny everything, but in most of the question which has been...
Be specific. What is the explanation to this incident in under 313? Because the victim herself says that it was accidental. What is this accidental incident the victim is talking about? Did you explain? Was it the accidental incident about pushing her? What is that accidental incident? Have you explained? Then? Yes.
Your Honor, if the incident which Your Honor saying that I'm admitting,
yes.
I'm not admitting that I got the victim.
What is that incident you're talking about? You explain.
In a 313, no.
This incident is what incident according to you? What you have admitted in cross-examination? Which incident you're talking about?
The
incident of slitting the throat, the incident of pushing her, the incident of drinking together?
Pushing.
Huh?
Pushing. The accused got agitated and thereafter he pushed me to the ground. That incident.
Yes. Yes.
Your Honor, the victim admitted before this court that her statement was never recorded by the police.
Huh?
She admitted in her cross-examination that her statement was never recorded by the police.
So what is the implication?
So everything what she stated about this case, it's the first time.
Which law says that the statement of the witness has to be recorded under 161 before it comes to the court?
No.
Which law says that the statement of the witnesses first has to be recorded under section 161. Then only a person can come to the court as a witness. If any such laws are there, please show me.
There's no such law.
Then what difference does it make if a statement was recorded under 161 or it was never recorded? If any law bars that the person who was never examined during the investigation or whose statement was never recorded under section 161 during investigation, he cannot appear before the court as a witness. Is there any such law?
No such.
Then what is your argument?
Your Honor, my some humble and respectful submission in connection with this case is that even though there are eyewitness, but the eyewitness failed to say that the accused person is the one who has committed this crime, Your Honor.
That's all.
Yes, sir. I pray before this court to kindly acquit the accused
Bring
person.
that thing. This PI, bring this one. Bring the knife. Bring it. No, no, no. Please read the statement under 161, 164, Exhibit 5 of the PW2.
164, Your Honor.
Exhibit 5.
One six one, Your Honor.
Exhibited as Exhibit 5.
It is only the last part, Your Honor, on the line. It's mentioned there, Your Honor, which has been on the line.
Yes. Exhibit 5.
Yes, sir.
You contradicted her.
Last part, if I may read, Your Honor. While I was inside, I lost consciousness, and when he cut my neck, I could not recall. That was the part, Your Honor.
So this was confronted to the IO. Who has exhibited this?
It come on the cross, this
What?
part.
Cross of the IO.
Let's see.
During cross-examination with the IO.
Let's see.
It is in point number 20, Your Honor.
PW?
He did last one, Pitbull 7.
Point number?
Point number 20, Your Honor, in the cross part.
Hardline counsel, Hardline prosecutor Sri so. You finish?
Yes, sir.
No, keep it. Hardline prosecutor so. Hardline defense counsel Sri so. Now, before this court evaluates the evidence which is unfolded during trial, it would be appropriate to briefly record the facts of the case which has given rise to the instant criminal proceeding. Brief facts of the case. The instant criminal proceeding was triggered by FIR dated 26/10/2018, filed by
Champang Nathong, Shri Champang.
Shri Shempang Lathong bracket PW1. Before the Raliang outpost, alleging that Srimati Barbira, alleging that Srimati Barbira Suchiang suffered an injury on her throat on 26/10/2018 at around 10:30 am. The injury was caused by Gerald Suchiang, bracket accused, the accused had slit the throat of Babira Suchiang with a knife while she was at her residence situated at Mukhap. The injured was taken to CHC Laskin for medical treatment. Later, she was referred to Joy Civil Hospital. The FIR was forwarded to Joy PS and it was registered as Joy PS case number 236 bracket 10 18 under section 326/307 IPC, and the case was endorsed to SID Chalam for investigation. During the course of investigation, the IO had made a seizure of a local dog on 26/10/2018 after being produced by the accused. I also prepared sketch map of the PO, comma. Further photograph of the PO was also taken. A further photograph of the PO was captured. Statement of the victim was recorded. The victim was medically examined. The investigation concluded in CS number 2/2019, dated 13/1/2019, under section 326/307 IPC. The prosecution, the investigation, relying upon the statement of witnesses examined during investigation and the materials that sent the accused for trial. The committal court, after taking cognizance of the offence and complying with section 207 CRPC, sent the accused for trial before this court. Charge was framed against the accused under section 326 IPC and under section 307 on 8 August 2019. The accused pleaded not guilty to the charge and demanded trial. The prosecution, during the course of trial, examined 7 PWs, exhibited 6 documents, and 1 material exhibit. The details are incorporated in the appendix of this judgment. After examination of the accused under section 313, the accused was given an opportunity to bring defense witnesses, comma. The accused declined. As such, the matter proceeded for final argument. That after hearing the rival counsel, and on scrutiny of the evidence which has unfolded during trial, the question which emerges for determination, not the question, the points which emerges. All right. The question which emerges for determination are as follows. Number one, whether the accused was present in the house of the victim on 26/10/2018 at around 10:30 p.m. and he had a verbal spat with the victim. Whether the accused had inflicted cut injury on the throat of the victim on 26/10/2018 with the intention to cause death of the victim. Whether the accused had inflicted voluntarily grievous hurt on the victim using material exhibit 1 reasons and the decision. Number one,
Whether the accused was present in the house of the victim on 26/10/2018 at around 10:30 p.m. and he had a verbal spat with the victim.
all right. For the purpose of determination of the point above, the evidence of PW2 bracket victim and PW3 is very vital. PW2 victim has stated in evidence that the incident took place on 26/10/2018 at around 8:30 am. When the incident took place, she was in her residence at Mukhap village, along with her youngest daughter, PW3. The accused was also present. PW2 was preparing to go to the paddy field, and she asked the accused by tapping him to join her, to join PW2 to the paddy field of her sister at Mukiao village. The accused got agitated and pushed PW2. She fell on the ground and became unconscious. Stop. PW2 also stated in evidence that her daughter PW3 was present in the house when she fell unconscious. In cross-examination of PW2, the defense has failed to elicit any evidence which would disturb the evidence of PW2 that the accused was present in the house of PW2 on 26/10/2018. The evidence of PW2 corroborates with the evidence of PW3 who stated that on the day of the incident, PW2 was drying paddy outside her compound and the accused was present in the house. It was a reaping season. PW2 instructed accused to go to the paddy field for cutting the paddy. The accused refused, and there was a verbal spat. PW2 and 3 were present in the house. They are the best person to reveal. The evidence of PW1, PW2 and PW3 clearly establishes that the accused was present in the house of PW2 on 26/10/2018. This court has not looked for any other evidence. Inasmuch as none of the witnesses were present in the house when the incident took place. Next point.
whether the accused had inflicted a cut injury on the throat of the victim on 26/10/2018 with an intention to cause death of the victim.
The FIR in the incident case was filed by PW1. The facts stated in the FIR reveals that the accused was alleged of slitting the throat of PW2 PW1 was never present in the house when the alleged incident took place. The evidence of PW1 reveals that on the day of the incident, he was passing through the house of PW2 and he saw the son of the victim lying in the compound of the house. On inquiry, PW1 learned that PW2 was assaulted. On inquiry, PW1 learned from the son of the PW2 that PW2 was assaulted, but the son did not know who was the person. PW1 immediately informed the village members and the clan members about the incident. PW1 was requested by the clan members to take appropriate action. PW1 contacted one of the villagers who was working at district council office, Joy. PW1 was informed that the police would be reaching at the village very soon. The police did not arrive. As such, PW1 along with the family members of PW2 took PW2 to Latsken CHC for medical treatment. Police arrived at Latsken CHC. It was there. Clan member decided to report the matter to the Dalian outpost. PW1 had simply put his signature in the FIR. without understanding the content of the FIR. The FIR has been exhibited as Exhibit 1. Upon going through the evidence of PW1, this court finds that PW1 is silent about the facts stated in the FIR, naming the accused person. The son of the PW2 was never examined. The clan members who decided to file the FIR were also never examined. More importantly, the facts alleged in the FIR and the source of the information of the facts alleged in the FIR has not been established. Coming to the evidence of the injured victim, PW2, she has simply stated that the accused pushed her to the ground while she was inside the house and she became unconscious. PW2 further stated that her daughter PW3 was present in the house when she fell down and became unconscious. The daughter PW3 stated in evidence that she saw the accused and her mother PW2 had a verbal spat, but she's silent about the accused pushing her to the ground. No, she's silent about the accused pushing her mother to the ground and inflicting slit injury on the throat. PW1, who is not only an injured witness, who is not only a victim, but an eyewitness to the incident. She stated in her evidence that she did not know who had lodged the FIR. She also, PW2 also stated that The accused have never stated. No, she also stated that. She also stated that she nowhere stated that the accused had inflicted cut injury to her. The statement of the PW2 was recorded during investigation under section 161 of CRPC, where she stated that where she stated that while I was inside, I lost consciousness, and when he cut my neck, I could not recall. No, where she stated that, no, where she stated that quote, huh? The accused suddenly grabbed my neck and told me not to say anything, to which my daughter and my sister took me to my daughter's house near my house, and then Gerald again came to my daughter's house while she went to search for help. Stop. While I was inside, I lost consciousness, and when he cut my neck, I could not recall. The statement under 164 for the purpose of contradiction was exhibited as Exhibit 5. The witness, PW2, is silent in her evidence with regard to the accused cutting her throat. The IO, PW 7 was confronted with Exhibit 5 and she stated that the statement under 164 Exhibit 5 is correct. The evidence of the PW4 with regard to the injury inflicted by the accused before the police under 161 of CRPC bracket Exhibit 5, and her evidence before this court is highly inconsistent, and through the IO, contradiction is brought. The evidence of the victim, who is also an eyewitness to the incident, is contradictory. With regard to the accused inflicting cut injury, stop. The victim was medically examined by the doctor PW.
PW6.
PW6. The medical report is placed, has been exhibited as Exhibit 6. From the medical report, it emerges that the doctor found 10 centimeter into 5 centimeter incise wound incise cut throat injury, not wound, incise cut throat injury involving interior aspect of the neck below the chin. This court finds that the injury measuring 10 centimeter into 5 centimeter on the throat is a serious injury, and that too on a person who was unconscious. Stop. The medical report also reveals that PW2 was under the influence of alcohol. However, she was under self-control. The injury, according to the doctor, PW6
Yes, sir.
was a grievous injury. The question which arises is, who had caused the injury? The learned prosecutor has argued that this is a case of a circumstantial evidence. The accused was seen in the company of PW2 victim and PW3 on 26/10/2018. Thereafter, PW2 was found unconscious with a slit injury on her throat. The accused was last seen with PW3. It is for the accused of PW2. It is for the accused to explain what happened in as much as the accused is the best person to explain. Prosecutor submits that Section 106 of the Evidence Act casts the burden of proof to explain the facts which is under exclusive knowledge of the accused. And if the accused fails to explain, adverse inference can be drawn against the accused. Against the accused, taking aid of Section 114 bracket G of the Indians of the Evidence Act. Next one.
Whether the accused had inflicted.
No, one thing. This court finds that the argument advanced by the accused, by the prosecution, on the face of the record is not sustainable. Inasmuch as this is not a case of the accused was last seen with a person and the person was found dead. Under such circumstances, it is for the accused to explain what happened to the person. In the case in hand, the person who was last seen with the accused suffered injury and had appeared before this court as PW2. PW2 is an injured witness to the incident, and she is the prosecution witness. If the person who had suffered the injury has not testified who caused the injury and under what circumstances injury was caused, the principle of last seen theory will not come to the aid of the prosecution. Full stop. The prosecution has also impressed upon this court that this is a case of circumstantial evidence The law laid down, stop, colon. The law laid down in Sarat Birdi Chand. Just see, Sarat Birdi Chand versus State of Maharashtra, 1984, volume 4, FCC, page 116, is the punch seal. Is the punch seal of circumstantial punch seal on circumstantial evidence. The relevant paragraph is reproduced. Just give the relevant paragraph. In order to take aid of the circumstances, to rope the accused for the culpability, the prosecution has to first establish the foundational facts from where only one inference can be drawn. That is the guilt of the accused. In the case in hand, applying the principle of law laid down in Sarat Birdichan Sarda Supra, this court finds that the prosecution has failed to lay down the foundational facts to the evidence of PW1, PW2 victim, that the injury was caused by the accused. If the prosecution has failed to establish through the evidence that the injury was caused by the accused, seizure of the weapon, material exhibit 1, is of no consequences. If the eyewitness if the injured witness has failed to testify that the accused had caused the injury, it is extremely difficult for the prosecution to establish the crime through other independent witnesses. The prosecution had never declared the prime witness PW2 hostile to extract the truth. While appreciating the evidence at this court, cannot give different meanings to the words uttered by the witnesses. The other evidence which has come during the trial relates to the treatment of the PW2, seizure of the weapon, medical report of the victim, it loses its significance after the star witness PW2 has failed to support the prosecution case. This court finds that the prosecution has failed to establish that the accused had inflicted the injury on PW2 with an intention to cause her death. The prosecution case for a charge under section 307 fails due to insufficient evidence. Stop. Next one. The other point.
Whether the accused had inflicted voluntarily grievous hurt on the victim using material exhibit 1.
This court has already discussed above that the prime witness PW2 has not supported the prosecution case with regard to the injury suffered by PW2 when the prosecution has failed to establish that the accused had caused any form of an injury to PW2, the prosecution case also fails to establish that the accused had caused grievous hurt with a dangerous weapon to PW2. Conclusion. That for the reason discussed above, on the points which emerged for determination. And this court finds that prosecution has failed to establish the charges due to lack of evidence. Stop. The accused so is acquitted of the charge under section 307 IPC and section 326, 307, 326 IPC and set at liberty unless wanted in some other case. Bail bond of the accused shall stand discharged without any further order. The IO is directed to destroy the material exhibits after the expiry of the statutory period of appeal. And one heading is compensation. At the conclusion of trial, irrespective of the accused is acquitted or convicted, the court is under statutory obligation to exercise its power under section 357A of CRPC either to grant compensation to the victim, either to grant or refuse compensation to the victim. In the case in hand, this court finds the victim is PW2. She had suffered injury which is very serious in nature. The medical report exhibit 6 describes the injury. The victim had to undergo treatment and she was admitted in hospital for a week. This court finds that PW2 did not come forward and support the prosecution case. Her evidence was detrimental for the prosecution case. But she did not depose in favor of the prosecution. And she did not depose as desired by the prosecution. Her evidence was contradictory. It appears from her evidence that she was more in a compromising mode. And had given an impression to the court that she wanted to shield the accused. This court finds that the victim PW2 is not entitled to any compensation for the reason discussed above. Under the victim compensation scheme. Please stands disclosure. Just give the paragraph, okay? Highly obliged. C13. What is it? What was your name? can't take it. We can't take Shivanchi now. We're tired. It's 3:13. That's enough for the day. Yes, anything else?
Bail acceptance.
Huh?
Acceptance one.
Sure. Where are the bidders?
Yeah, they are outside.
When did we grant bail? Is it in-
Day before, Your Honor.
Who is he?
He's the uncle, Your Honor.
What's the bail amount?
20,000. And she is the mother, Your Honor.
Did you explain her?
Yes, Your Honor, I have.
Today,
29.
Where's the release notice? With the terms of this. Okay. So explain them, he'll appear. Where do they reside?
One is in Mintkong, one is in Minskia.
No, where will this person reside after being released?
Mintkong village. I
Where's
with
this
his
village?
mother. Not far, Your Honor, just half an hour or
All right.
45
Please
minutes.
explain them.
Yes, Your
He's
Honor.
the brother,
He's the uncle, yes, brother and mother.
brother of the
Yes,
lady. So please explain them that this man has to come to the court
yes, Your
and face trial.
Yes, Your Honor.
And if he doesn't come, they have to pay
Yes, Your Honor. I have.
the bail amount.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Bring this, give me this book.